Well, good morning, everybody. I'm Amy Pennekamp. I'm an attorney in Bill's law firm. And in addition to estate planning, I also do a lot of Medicaid planning, helping clients that are going into the nursing home qualify for Medicaid and preserve assets if they can. There's some last-minute techniques that are still out there. The nursing homes won't tell you about them, but there are some ways that you can salvage some assets and not have to spend it on nursing home care. And I also do probate administration when somebody passes away, administering their estate through the probate court. So in this last session, we're going to cover the top 10 estate planning mistakes. I'm going to cover the first 5, and then Bill's going to finish out the morning with the last 5. So if we start with the handout, the first estate planning mistake is the failure to have a current updated last will and testament stating who will receive your property and who will be appointed guardian to take care of your minor children. Clients are often surprised when I tell them, it's fine if you don't want to have a will, but the state does have a will for you, and you may not like what the state provides. If you die without a will, each state has laws of intestacy, which basically states who will receive your property upon your death. And for instance, in Kentucky, if you die without a will and you don't have beneficiary designations on your assets and everything passes under probate, Kentucky law says half goes to your spouse, half goes to your children. Well, if your spouse is the parent of your children, typically you want to leave everything to your spouse, and your children aren't going to receive anything until after your spouse passes away. So it's very important in Kentucky to have a will. In Ohio, Ohio does it a little differently because they try and account for blended families, that if you have children from a prior relationship, making sure those children are not excluded. So Ohio does a calculation, but unfortunately I have seen at times where what you wanted the state law would not be good for what you wanted. I currently have an estate right now that I'm administering that the decedent died without a will. She was never married, she never had any children, and her 3 beneficiaries are her 3 siblings, which doesn't sound bad, you know, to leave it to your 3 siblings, except for the fact that 2 of the siblings are incompetent, living in nursing homes on Medicaid, and basically their inheritance, once they get their inheritance, they're going to be able to prepay their funeral expenses, and then everything else is going to go to the nursing home. So basically, 2/3 of this woman's inheritance is going to nursing home care, and these people will get kicked off of Medicaid. They'll have to spend this money down, and once it's gone, then they'll go back on Medicaid. Had I met with this woman, I did not know her while she was living, I would have advised her to, instead of leaving it to siblings, leave it to those siblings' children so that they could have used that money to supplement mom and dad's care. So sometimes it doesn't turn out the way that probably the person would have wanted it to. I had another case recently where a gentleman had a longtime girlfriend, and so I said, well, do you have a will? Yes, I have a will. Can I see the will? The will was not valid because it was only witnessed by 1 person, and to have a valid will in Ohio, it has to be witnessed by 2 people. So if he actually has had some health issues lately that he actually didn't think he was going to live. And so we quickly did a new will, because if he would have died with the will that he had, his girlfriend would not have received the assets. It would have went to 2 nieces and nephews that he hasn't spoken to in years. So that was a case where we were able to quickly do something, but it doesn't always work out like that. The other reason why you need a will is that if you have minor children, the will is where you specify who's going to raise your minor children if something happened to you and your spouse or the parent of that child. And again, I've seen instances where the wrong people come forward, because ultimately what happens is if a guardian needs to be appointed, the probate court has the ultimate say as to who that guardian will be. So if you have named a guardian in your will, as long as that person is a fit person, they don't have a drug, alcohol, or domestic violence issues, the court will defer to your choice. But if you haven't specified who should be the guardian, then the court has to decide. And family is going to take priority, and you may or may not want family to be the guardian, or you may want a certain family member as opposed to another family member. I had a client last summer who was terminal, and her husband had already predeceased her, and she had 3 minor children that she wanted very good friends to raise. So we did a will to make sure that if something happens to her, that friends are going to raise the children, friends who live in Cincinnati, as opposed to family members that live in another state. She feels it would be traumatic for her children to have to move. So it's just important, we never think that we're going to die, but it's important to think about these issues, especially if you have minor children, and wanting to ensure that they're raised by the people that you want them to be raised. The second estate planning mistake is the failure to review and update your survivorship assets and beneficiary designations to make sure your assets are going to your heirs as defined in your estate plan. So maybe you did do an estate plan. Maybe you did a will. Maybe you're really on the ball and you did a trust. You can do all these things, but if you have beneficiaries on life insurance policies, 401ks, IRAs, if you have bank accounts that have a beneficiary on them, then it doesn't matter what plan you did, because those contract beneficiary designations will trump your will and they'll trump your trust. So, I just met with a young couple last week. We actually signed their trust. And so then we started talking about, okay, life insurance policies. We need to update those to make the beneficiary the trust. And they said, oh yeah, I think my mom, I think my dad, they're the beneficiaries of the life insurance policies. A lot of times you get a job, when right out of college, you put down a parent and you don't even think about it. And if something happened to you, then those assets would go to those heirs that are in that contract designation. So it's very important. We always work with clients after we do their wills and their trusts to really take a look at their assets and make sure 401k, IRAs, life insurance policies, that the beneficiaries have been updated to make them consistent with her estate plan. I see a lot of times elderly clients, they'll have a child on a bank account. If child is the co-owner on the bank account, then if something happens to parent, that bank account automatically goes to that child. They're the legal owner of that account. But yet mom or dad has a will that says everything goes to my children equally. In that case, that asset only goes to that child. They have no legal obligation to split it with the other siblings, even though that's what the will says. And I can tell you, I have had some instances where that child knows that they were just on the account for convenience purposes and that they're going to split it equally with their siblings. But I've also had instances where they don't split it with the siblings, because a lot of times people justify in their mind that that was supposed to go to them, or they have their own financial considerations, and so they don't feel that they have to split it, because they legally do not have to split it. So that would just be something I would caution you, is to go back and take a look at your beneficiary designations and how you have accounts titled, because it may or may not be consistent with the estate plan that you've put in place. So that is the second mistake. The third estate planning mistake is the failure to execute financial power of attorney and healthcare documents so your family can manage your finances and make your healthcare decisions if you are disabled or incapacitated. If you became sick or disabled, if you do not have a financial power of attorney, a healthcare power of attorney, and possibly a living will, and I'll explain what a living will is, then if you became sick or disabled, your family has to go to the probate court to get appointed your guardian to handle your finances and to make your medical decisions. A living will in Kentucky, the healthcare power of attorney and the living will are combined into one document. In Ohio, they're two. But the living will, which a lot of times you hear about in the news, the living will is your direction to your doctors that if you were terminally ill or permanently unconscious, you would not want life support, you would not want a feeding tube. So again, if you don't have these, then the family has to go to the probate court and get appointed a guardian. A guardianship is a very tedious process. It's an administrative burden. You have to account to the probate court for every penny that you spend on this person's behalf. you have to get pre-approval from the probate court before you can spend any money. And in Hamilton County, you actually have to get an attorney to co-sign on every check that you write from the guardianship account. So it really is an administrative burden. And I actually just got contacted yesterday by the Volunteers Lawyer Project. They asked me if I would represent a woman that has a hearing on February 16th for her father. The father is on life support at Christ Hospital. They want to move him to a nursing home, and she has to get appointed the guardian just to be able to move him because he doesn't have a healthcare power of attorney. And I mean, the thing I thought about first was, I don't know if this person will even be living by the time we get a hearing, in 2 weeks. So, the things that we take for granted, like you think, oh, I'm the family, I'd be able to do that. That's, they're going to let me, make medical decisions, or, the banks will talk to me about my parents. It doesn't happen unless you have those documents or you have to be appointed the guardian. I mentioned how I do a lot of Medicaid planning. It's very important that you have a financial power of attorney that incorporates the rights to basically do Medicaid planning, because oftentimes there are some last-minute strategies that we can do to try and preserve assets for somebody going into the nursing home. But a lot of times the person that's going into the nursing home really doesn't have capacity to be able to make decisions or do the gifting plans that we would put in place. And if those powers are not in the power of attorney, then the children cannot do the planning for the parent. I had a couple, a husband and wife, who they actually did have some significant assets, and both of them were going to go into the nursing home. And so we wanted to do some planning. I went through this whole analysis with the children about how we could save all this money, but that it was contingent on, do you have a power of attorney for your mom and dad? Because the mother had Alzheimer's and would not be able to do anything or sign a power of attorney at this point in time. And it took a while because they couldn't find it, but eventually they did realize that the prior attorney had done a power of attorney for their mother. He had a copy, and so now we can go ahead and move forward with doing that Medicaid planning. But had they not, then our hands would have been tied as to what we could have done, and it would have been disappointing. The fourth mistake is the failure to make sure your spouse and children are financially secure with adequate disability and life insurance if you become disabled or die. A lot of times people come in and they want to do their estate plan, and then we start going through the assets, because you really need to know the assets to be able to advise as to what plan we should put in place. And oftentimes we learn that the person either has no life insurance, no disability insurance, or they're underinsured. And we can do all this estate planning, we can put documents in place, but if the person is underinsured or doesn't have any insurance, it really can be devastating to the family if something happens. If you think about it, if something happened to you, would your spouse be financially secure if you died or become disabled? We've worked with several widows where they did have very good insurance and others did not. And it can really be a struggle, because if you put yourself in that situation, are you working right now? If something happened to your spouse, are you going to be able to go out and find adequate employment to replace that spouse's income? Are you raising minor children? How difficult would it be without that kind of financial security? And I met with a young couple recently that they were in their 40s. They got married later in life. They had a child later in life. They wanted to do their estate plan. And when I sat down and met with them, they had no insurance. And I kind of had to give them the harsh truth that, yes, we should do a will, but you really need to go talk to a life insurance agent, because if something happened to one of you, it would be devastating to the surviving spouse. Especially they were in a startup business, didn't really have a lot of income, and it would be very difficult. And the fifth estate planning mistake that I'm going to talk about is the failure to organize your estate documents, important paperwork, so that your family can take care of your affairs if you become disabled or die. A lot of times that's really overlooked. But if you step back and think about your situation, if something happened to you tomorrow, would your family, friends, would they know where to find your important paperwork? Or would it be a treasure hunt for them, is what I like to, is a nice way to call this situation. I had to help a client last week pre-plan their funeral because they didn't think they were going to make it through surgery. So we rushed around, we planned this funeral, and then I thought to myself, so what happens if he passes away and I'm not the one that gets notified? Is the girlfriend, because she didn't know we did it, is she going to know that the funeral's already been planned, what funeral home we use, what cemetery? And so I did communicate that to her so that if something happened, she would know, you know, where to go. But that's the thing to think about is, where do you keep all your documents? Do you keep them all together? We did a probate years ago where it was adult children. They really had never been privy to their mom and dad's finances, and everything was kind of a mess. And so every so many months we were having to go back to the probate court because they'd find a new asset in the house and then we'd have to account for it. So it's just very important to think about your paperwork and is everything organized? Would everybody know where to find it? And sometimes you may give copies of your documents to your family members. Everybody's situation is different. You know, you have to have a certain level of trust to want to give the documents to a family member. But I always tell people, if you don't want to give them a copy, at least tell them, if something happens to me, this is where I keep all of my paperwork. But I have worked with clients who their parents kept very good records, you know, they have binders, and I think the children really appreciated that. It really, a lot of times makes them really proud that their mom and dad were really organized and that they made things easy for them during such a difficult time. So those are the first 5, and Bill is going to cover the last 5 estate planning mistakes.
Well, thank you, Amy. And is the mic on? Seems like it is. I did want to mention there's a couple of handouts in your brochure that we'd like you to take a look at. That there is an outline that talks about the 40 years of celebration as being an attorney, CPA. But I just got, I don't know if you saw Cincy Magazine. It's coming out in the February issue. Just got mailed this week. Got recognized for the 13th year in a row as a leading lawyer in the trust and estate area. So we're very honored to be part of that recognition with Cincy Magazine. And I did want to mention, Amy is a former president of the Cincinnati Bar Association Young Lawyers group, as well as she's a rising star, and so a super lawyer. So we really, you know, appreciate, you know, those recognitions, because that's really a big part of our law practice, is working with clients on their estate planning. The other thing is there's an evaluation form that you may want to have some time over the last half an hour then to kind of give us some feedback. We are kind of interested in how you found out about this seminar, because we did a lot of marketing of this seminar. I'm kind of interested in how that resulted. And also, I did want to mention that those of you that have attended, you can contact us, leave this behind for a free 30-minute consultation. It might take longer, but just leave that information if you're interested in that, so we can follow up with you and schedule that if we can next week or next, you know, whenever you can, whenever you're, you know, available. So I want to mention those 2 things before we move in and finish up the estate planning mistakes that are typically made by business owners. So estate planning mistake number 6, the failure to make sure your heirs receive their inheritance over a period of time and not all at once, since, for example, most lottery winners go bankrupt within a few years after getting their financial windfall. It's just one of those things that I would say money is a curse. It's sad, but it's true that sometimes the money that you leave to your family can be the worst thing you ever do for them. And that's one of the reasons we use a trust in our estate planning a lot, so that particularly when you have younger children and as even young adults, And this thing with a lot of winners comes at all ages, quite frankly. So at times, our trust is set up that even for my children today, they might inherit a third when I die, a third 5 years later, and a third 5 years later, even though they're in their 30s and 40s. So they're allowed to inherit the property over time and adjust to having money. And if they make a mistake financially, make a bad investment, then they learn from their mistakes and they haven't blown the whole shebang, so to speak. So that is the purpose of a trust that we use very commonly, is to control, when we talk about who gets what and when, it's the when thing that the trust enables us to do. And so that you would have a trustee that would also be involved with your heirs, whether it's your spouse or your children. Your spouse could be the trustee, or you may want to have an investment advisor that works with your family on investments, so that if you're concerned about your family with their investments. We've designed things in a lot of different ways, and that's the whole purpose of a trust is to design exactly what you want for your family. And so there's a lot of variations, and we can explore that with you. But I think it's a very important feature. Actually, one of the newest things I've done with a trust for baby boomers, and something myself being a baby boomer, I recognize that our children, the baby boomers' children, and the young adults in their 30s and 40s, today's world, they're paycheck to paycheck. They're not going to have the opportunities that are out there necessarily to accumulate wealth. So one variation we have, quite frankly, is that the trust becomes a retirement plan for them. We control that basically they're not going to have access to the money. It's intended to be there for their lifetime. It's intended that if they became disabled for whatever reason, and the doctor certified that, then they would start getting an annuity out of the trust that would pay whatever's in the trust over their lifetime. Now, if you know what an annuity is about, basically you factor in an interest rate, and the money is paid monthly, and it's intended to basically provide a monthly income to pay that money out over their life expectancy. Let's say it's age 83. So if they can become disabled at 43, they'll have an annuity that pays out that a monthly amount for them over 40 years. Now, if they are working, another provision we put on our trust, quite frankly, is that you don't want the children not to work. The trust fund baby, you might have heard that term. So sometimes we'll put in a trust that they only get money from the trust if they work. And you can define how much you would want them to make, and you might match it. There's a lot of drugs and alcohol problems out there in the world today. I got to tell you, it's very real. 1 out of 8 people were really affected by alcoholism. The drug problem in northern Kentucky is very real with families. So parents are really concerned about their children, and it happens all walks of life. It doesn't, no class, no income, no education is immune from the problems that are out there. So we are designing our trust that basically shuts it down if that child becomes involved in drugs and doesn't work. That's usually one of the side things that happens. They start living off the trust fund to feed their drug or alcohol addiction. And that can happen in their 40s or 50s. So one of the purposes of the trust is to hold the children, it's tough love, but hold them accountable, and you don't want to feed their drug or alcohol addiction. It's tough. The other thing that I think is important too when we do our planning is that, I don't know if Social Security is going to be there for our children. I'm speaking as a baby boomer. Right now you always hear about that. And so are they going to have money available 30 or 40 years from now from Social Security? I'm scared to death about that. So part of the purpose for me in my estate plan is that I want that money to be held in trust. And they're going to get some income during their lifetime. This helps supplement their work if they're working. I put all these provisions in my trust last year. I designed this thing. So it's coming from the heart. It's my love of my children. And they're going to have something there that I don't know what Social Security is going to be available for them, but they're going to have a retirement plan. It's intended that when they turn age 62, that whatever money is left, whatever's in the pot, is going to be paid out over their lifetime, anticipating that they're not going to have much that they can rely upon with Social Security. And also my concern whether they're going to be able to accumulate the nest egg. over the next 40 years. So this is how we use a trust. It's very creative in a way. It can do a lot of different things, but I think it's, to me, I really am very, interested in working with clients on every family is unique. The children are unique. Ozzie and Harriet does not exist. I can tell you that. We see it every day in our practice. Yes?
Just out of curiosity, when you're setting up a trust, do you have to look down the road and say, okay, I'm giving this to my children, something happens after you pass away, they pass away, how does that, do you have to designate that then it would go to their children, or do you have to look that far down the road with a trust?
We do, absolutely. We look at all possibilities. So that typically, and it's not unusual, we keep it in the bloodline. It's called per stirpes. So we'll leave assets in trust for the benefit of the children. Then we have a trust then for the grandchildren, basically, in that scenario. Sometimes you have special needs children that we had a client in that his son is in New Mexico, fully on government support. There is a special trust we can do in that situation, so it's a supplemental needs trust. But he chose, there's two choices. You can do a trust that says, we'll provide for the child for things that the government doesn't provide, but if they lose the government support, they're disinherited. It's the poison pill. Ohio allows us to do that. However, he chose basically to say, you know what, I'm going to have my other children inherit the money. They have a moral obligation to take care of their sibling. So there's two ways of handling that situation. Okay, yes.
What if, like, that money, like the first situation you said, that if he loses the government money, that the inheritance is lost, and there's nobody else to get that money, who gets the money?
Well, you identify, it could be your family tree. That's how it would typically work.
If there's no family, let's just say, worst case
In
scenario.
the state of Ohio or state of Kentucky. I mean, you can designate, that's why you want to trust. You decide, it could be a charity, your favorite charity.
To a charity,
Yeah,
okay.
yeah, exactly. A lot of times we have clients that use, really, they don't want we don't want the mom and dad because it's going to go to the nursing home. So a lot of times in a trust, we provide that something happens to, a couple and their children. We don't want it going to mom and dad. It goes to their siblings and we disinherit mom and dad.
Right.
Or else they got to use it for their nursing home.
Have you ever had situations where, like, you have that, and it's 50 years down the road, and that company's not in business, or that charity's no longer in business or something?
We provide for that specifically, whether you want it to lapse or whether you want to provide another charity that does the same thing.
Oh, okay.
So we
Wanna make
cover
sure it's
all,
all covered.
we go into that type of detail,
Okay.
absolutely,
Okay, good.
very much so. Any other questions? Good questions. Well, the estate planning mistake number 7, the failure to control the estate plan upon the death of the surviving spouse so that your children and family get the same inheritance regardless of which spouse dies first. It's interesting because of pension plans, life insurance policies are beneficiary designations, annuities, you have beneficiary designations. The question becomes, sometimes what we'll do with the trust is everything, the trust is the beneficiary of everything. So we have one pot. And we guarantee that no matter who dies first, those assets going in there will be held for the benefit of the surviving spouse and typically their children. And I got to tell you that the simple plan is not necessarily the best. We say, well, I'm just going to leave it to my spouse and then they can leave it to my children down the road. This happens every day. I got to tell you, you hear it in the National Enquirer, but we have a client. Dad's 2 years ago, mom died, and he was 80 years old. 4 months later, he got married to the cleaning lady's mother. It took him 9 months to get the marriage annulled. Hamilton County would not prosecute them criminally or anything. They chose not to. And they're still trying to recover assets. Okay? This happens. So in the elderly are preyed upon. It happens all the time. Financial elder abuse is very real. Yes?
Is there a way to prevent that?
Well, what we do is we basically lock it into a trust then, basically, so there's a trustee. Now, again, what we try, the point is that, and I had this happen with a client. Dad was widowed. Mom died. He was in Hawaii, up in Chicago, 80 years old, girlfriend 65. And this is a perfect example. So they're in a hospital, and he's bringing Dad back to northern Kentucky. And he says to the girlfriend, as they're packing up the apartment, getting ready to move, you know, Dad's got a trust, and you're not going to get anything. She didn't go back to the apartment and pick up anything. She just disappeared. Okay? Real story. True story. Okay? So we have a trust that locks it down and that, you know, basically it does provide for the health support and maintenance of the surviving spouse. Okay? But that's where they can hit. There's some cases where they try to take all the money out and the children have the right to go after the second spouse that is trying to get the money from the surviving spouse and can go after that money to get it back. They have a legal right, yes.
Do you have case studies of when you put your children into your trust, where maybe your children's spouse becomes a problem?
Well, that can be usually it's a bloodline. We disinherit the in-law. Okay, so I got to tell you, that's very real. And it's very rare that a client will include an in-law. So, for example, if a child dies, it's held in trust for their children, their grandchildren, excluding the spouse, the in-law. And if there's no children, it goes to the other siblings and not to the in-law.
So it's a common practice where you don't involve your
You exclude the
children's-
in-laws.
Yep.
You exclude the in-laws. Yes, absolutely. And that's just common, I'm saying. There are certain situations where the parents like the in-laws better than their children, and they are included. True story. Okay. Estate planning mistake number 8. Failure to use a trust or survivorship or beneficiary designations to avoid probate upon the death of the surviving spouse to save the cost of probate as well as to keep the estate plan for heirs private. Good example, R.C. Durr. Died. Had a will, no trust. Headlines of the Kentucky Post. His spouse got X dollars and a house out of his $80 million. Totally disclosed all of his estate in a hidden. You have to, it's public information. Do you want your family, friends, and neighbors to know everything about your estate? And you have to list your assets in probate. Okay? So that's one of the benefits of having a trust is you have privacy. You do avoid probate on your pension plan. It's a beneficiary designation, life insurance, annuities. But again, a lot of times your house or, you know, in his situation, it was if the investment account is just in your name, if you don't have a trust, it's in probate. And then look at Prince. Oh my gosh, his estate. Everybody's saying, I'm a kid. They're still trying to figure out how many kids he's got. DNA tests are still in process. Yeah. And I think the other thing, too, the cost of probate. There is a cost. And while we do a trust, we do the best we can so our clients do not have probate. And there aren't many attorneys out there that do that. They'll put a trust in place, and they don't set everything up and do the follow-up so there's no probate because guess what? The attorneys get a lot of money. We had an example that came out that the person didn't have a trust. They had a $20 million of P&G stock that was in probate. I think the attorney agreed to a fee of $40,000, so, you know, for one asset. Okay? Estate planning mistake number 9, failure to use a trust to control the voting stock of a family business, using the trustee to execute your succession plan and protect the business from legal problems if heirs get divorced. Okay? So, you know, a simple estate plan just without a trust just leaves the stock to your children, let's say, and they get divorced. Well, you know, there's case law that if that family member is important in the business, and even though you get divorced, it's usually a non-marital asset, but if that person is directly involved in the business and contributes to the success of the business, that increase in the value attributable to the efforts of the spouse is a marital asset in a divorce. Okay? So what I'm trying to share with you is that you know, if you have a trust, you can leave the asset in trust for your children, and it's excluded, and there's no right that they have because the trust controls the rights of that child, and that you control in there that it's basically not a marital asset. It's inherited, but that it's excluded from the marital estate. So you want to use a trust in that situation. And then the other issue could be that you may leave stock to your children in the company, you die, and then when they die, let's say they die unexpectedly, their spouse inherits the money. So the in-law owns stock in the company. You may not want that, okay? And now, if it was held with a trust, you can control that it's going to be held by the family, and you can make provisions when the children die, who's going to, what's going to happen. A trust can control that. Yes, question.
Do you have a checklist that brings out all those scenarios so that things like, I wouldn't think about that down the road, but that's
Yeah.
situations of authority?
See, that's called sales and marketing. It's all up here. I had to put that in. We do have a questionnaire form we use for married couples, but quite frankly, it's a matter of every situation is so unique. I really have not developed I'll be honest with you, I haven't developed a checklist, but it's one of those things I don't want to give away. I got to tell you.
You don't have to give the checklist, but
Yeah. Yeah.
brings out your services.
That's when we
you're
beat.
doing it,
Yeah.
I would like that organizational chart to think of all those scenarios.
That's exactly what we do. We sit down and say, what if, what if, what if? And that's really one of those things, and that's a good point, yes. And we do have some questionnaire forms we use for married couples, okay, that helps then evaluate, when they have children, or even if you're single. Same issues. If you're single, you got the same issues. What's going to happen in your business? You die or become disabled, okay? State Farm had a thing that I think they sold 400,000 life insurance policies to adults age 45. And they also had a statistic that within a year, 400 of them cashed in. Okay? There's a probability at age 45 that you will die unexpectedly. Usually it's a car wreck, but I gotta say cancer. Cancer is very real out there for women. I gotta say with breast cancer, it's just sad. I mean, that's a very real truth out there. So that's why we try to plan for the worst, expect the best. Okay, that's the whole strategy here. So let's go to the estate planning mistake number 10. Failure to set up a buy-sell agreement as part of your succession plan to limit the marketability of the stock ownership being inherited by the family members and to control how the buyout price is to be determined upon death, disability, termination of employment, or other triggering events. That's a mouthful. What's it mean? Well, you can leave stock to your children, okay? Let's say you do. You have no plan. You have no buy-sell agreement. Just leave it out. I'm going to leave it to my kids. Well, each child can do whatever they want to. You know how your children get along really well together? All of them? And they can say, when I die, I'm leaving it there. All of a sudden, the in-law is in business with your children. And that will happen. Okay? Now, you can have a buy-sell agreement that says that when you leave the stock to your children, that they agree that is part of the deal, that when they accept the ownership of stock, that they're agreeing to the buy-sell agreement that mom and dad have put together that controls who can own stock in the company and who's bought out and at what price. That's the other thing, because that's part of the deal too. Some clients are saying, well, I gave them the stock. I don't want them to get a windfall, so they're trying to figure out how to split up everything to be fair to the children. You float that boat. One child gets the company, the other children get cash in the real estate. Who won? Well, it depends. I've seen it go both ways. The children are acting in the business. They got to make the business work. They got to make the succession plan work, and they might have nothing at the end of the day. And the other children got the cash in the real estate. Sometimes there's real estate involved in the business. So we try to have the real estate. So I've had clients who have the real estate go to the children not in the business. We try to do a long-term lease to protect the business so that the children with the real estate cannot extort and charge excessive rent for the family members that they're jealous of. They're being successful in the business because the business ended up being successful, so they don't want fair rent. They want their share of the pie, so to speak. We've seen all kinds of scenarios play out. The purpose of the buy-sell agreement, then, it will control which triggering events is going to require the family members to have their stock bought out. Death, disability, it could be termination of employment. You know, it could be, what if they stop working? We have that where, not when they're terminated, but they could be terminated by the company for not doing a good job, or they could be out there, you know, not doing anything, and so they've kind of retired, so to speak. So we do try to work through the triggering events is what we call them, and then we try to identify what's the valuation price going to be. As a CPA, I serve as an expert witness in divorce cases valuing businesses. Been doing it for years, so I'm helping clients when they put a buy-sell agreement together, coming up with a strategy to identify what the buyout price should be. Should it be a formula? Should it be a set price that is agreed to annually by the owners of the company? And there's a default provision. If they can't agree, then we have an appraisal process that kicks in. So we have a lot of different strategies that we use, and every business is very unique. So we have to try to come up with a plan that basically we're looking at the family, the parents are leaving the business to their children, and they want to control then how that buyout price is going to be computed. And they can lock it in, and it's their decision. We have some clients that said, you know, you're giving it, so you're only going to get $1 when you leave. If you're active in the business, we have some clients say you got to be active in the business, and if you're not active in the business, you got to turn your stock in for $1, or for whatever value they determine. Any other questions? Taxes, succession planning, estate planning. We're getting near the end of it. Yes.
You mentioned, the associate had mentioned, if you do not have a will, in Kentucky, the spouse gets 50% and the children the other. What if they own property in Ohio? Does it matter? If they own property in Ohio as well?
It doesn't matter. It's based on where your legal residence
Yeah.
is. So Kentucky law will apply.
Kentucky law controls. Okay, you might have ancillary, they call it ancillary probate jurisdiction over in Ohio, but that asset really is governed by the laws of Kentucky as to how it gets divided among your children. You need to go to probate court in Ohio to get the property transferred to them, but your will under Kentucky controls all your assets, even though it's in another state. That was a good question. Any other questions? We're getting here. Yes.
Section 179, is there one for 217? If there is, what's the maximum amount? Deductions, section 179.
Okay, section 179, the maximum you can take in any year is $500,000 a year, and there's a phase out if your assets that you purchased during the year are more than $2 million. So for most small business owners, you don't have to worry about it. It's just so large. It has to be new equipment, by the way. It cannot be used equipment.
So it is available for 2017.
That is correct. Yes, exactly. And that is in the tax guide. It talks about that. So there's a page number reference there too on depreciation. Okay. Any other questions? Well, I'm glad you were here. Oh, yes.
The government, the Congress for years has been talking about tax reform. And now with our new president, do you think we're going to see a lot of tax reform in 2017?
Let me share with you, this is what the senators and congressmen have been talking about the last couple of weeks on the Sunday morning programs. I'm glad you brought that up to wrap it up here. As far as the Trump program, they don't expect to vote on any legislation until the end of August, the summer recess. So it's not going to happen in the first 90 days. He's got other agenda items on his plate. What we do know is that Trump wants there to be an incentive for businesses, because what's driving this is that the corporate tax rate is 35% for businesses. And that's the second highest rate in the world. So Trump wants to reduce it to 15%. The Republicans want to, Ryan is 20%, the Democrats are 25%. Okay, it's going to be somewhere, I think, in the 20 to 25% range. What that means for business owners is they cannot discriminate against just corporations against everybody else, but we don't know what's going to happen. They also do not know whether the changes will be effective this year, retroactive to January 1, or beginning January of next year. So you'll have to kind of just keep following the newspapers and the press and see what happens. It's really an open book. We do expect there to be a change. We just don't know when it's going to happen, whether this year or next year. And we don't know the exact details, whether it's going to cover sole proprietorships, partnerships, S corporations, to what extent versus C corporations. So that's kind of the snapshot of where we are right now. Just a lot of uncertainty, but we are expecting there to be a tax break this year. Well, thank you for your attendance. If you could leave your questionnaire forms and if you want to do an interview, maybe in the back table with Carrie and Kathy back there on your way out. If you have any other questions, be sure to call. You can call me on my cell phone. The business card's in there. Call the office with Amy, Kurt, Carrie, or Kathy, and myself. We'll try to help you out. And we thank you for your attendance this morning. And this program will be on our website. I don't know when we get the videos, so you will be able to come back and in the comfort of your home, go into our website and actually listen to the program one more time if you like. Thank you very much.